What is discovery in divorce? So discovery is, simply put, the process of finding information or gathering information from the other side. This can be done in person in terms of depositions, where they orally give answers, or more effectively, money-wise, is it can be done written in requests for production, requests to admit, and other forms of written discovery. What types of information are collected in discovery? So the most common type of information collected in discovery would be financial information, especially the financial information above and beyond the basics you get with an FL-150, that financial disclosure, where it's just the last two pay stubs and signing a declaration saying this is your true and correct income. We can dive in and we can get old bank records, old credit card statements. We can get information on wire transfers. So any and all financial information. Also, when it comes to custody, if it's a messier custody situation, we may need to find out the kid's school or other personal information that's being withheld from you about the kids. And then lastly, one of the most effective ways, especially when it comes to allegations, are discovering text messages, emails, communications between the opposing party and a therapist or an evaluator, or between them and another person talking about the situation. So it can be anything and everything. It's mostly financial. You'll get some information about the kids, and then there are certain situations where we really want to press on getting that written communication between the opposing party and a third party. How should you respond to discovery requests? Well, I'll tell you how not to respond to discovery requests, to ignore them. Most discovery requests have between a 30 and 45-day window to answer. So we are going to answer, we are going to respond within that time frame, because if we miss that deadline, then we have a situation where we can't fight the requests. Now, when it comes to fighting requests, there are proper means to discovery, and then there are improper, intrusive, invasive, overly broad methods of discovery. If someone is requesting information and they are entitled to that information, we want to comply with that. We don't want to hide the ball. That can lead to very large attorney fees, sanctions, different issues with evidence later in your case. So if they make a true and correct request when it comes to discovery, we are going to comply. If they request information and it violates a rule of evidence, it's too broad, it's irrelevant, it's designed to harass you, any of these issues, we can object to that, and the other side then is going to have to go to a process to overcome that objection. Are there ways to use discovery strategically in court? Discovery is a very strategic play, a very strategic tool in terms of how to navigate your family court case. Unfortunately, discovery can be one of the more expensive pieces of your case. But if used correctly, we can discover information and get to a settlement much quicker than if we didn't have said information. If you're going through divorce, child custody, and you're facing discovery or how to navigate discovery, click the link in the description or give us a call at that phone number to schedule a free case evaluation with our team to see how we can successfully help you navigate family court.